All right, we will get started. I know it's almost 1 o'clock or right at it. So I know everybody has a busy day, so we will go ahead and get started and let you get back to whatever you are doing. I got a few screens here, so you may see me looking around a little bit, but I promise you have my full attention. I am Scott Mastley. I am the Chief Human Resources Officer with Thread. Our website is threadhcm.com. And today, we're going to talk about accommodation requests, multiple kinds of accommodation requests. So not just disability, but also religion and other kinds of accommodation requests. Like, what are they? When do they apply to you? How do you respond? What should you do? What should you not do? All of the basics. The Americans with Disability Act is written pretty clearly, but it is difficult to interpret sometimes, and even more difficult to implement effectively. So we're going to dig into it as much as we can during our time today in the webinar. I appreciate you joining us. So we will go ahead and get going. Let me click over here. There we go. So a little bit about Thread. We are a female-owned business. We've been around for 20 years. We basically sell payroll software and HR services, which include HR consulting, managed payroll, onboarding, and other things, support for whoever is wearing the HR hat, whether that's one person with or without HR experience or a team of HR people. We're here for you, and we have packages and pricing that can scale up and down with your business as your business scales up or down. So call us, reach out anytime. Let us know if you're interested in talking about that and how that would work with you. Or if you just want to connect, reach out to me. I'm always glad to connect on LinkedIn as well. Or if you just want to network as an HR peer, reach out as well with that. So thanks for joining. You are going to get credits for participating in this webinar today. It is pre-approved for HRCI and for SHRM credits. Following the webinar, you will get a email that is going to include these slides today. So you don't have to take pictures of slides or anything. You're going to get all of them. And then you're also going to get a bunch of useful resources. For example, an ADA interactive guide, a form that you can use to walk through the interactive process. You're going to get a little bit about FMLA and the overlap with ADA and multiple other things. So you're going to get a bunch of goodies for free for signing up for this webinar, along with credits, and those will all be in the follow-up email. And then whenever we do a webinar for our clients or for general public or prospects, we record the webinar, and that will be posted on our website as well. You can always go to the resources page on our website, threadhcm.com, and see all of the free webinars that we've done in the past, and you're welcome to check those out whenever it's convenient for you. So a little bit about what we're going to talk about today is what are accommodation requests, who qualifies, how many employees do you need to have, and does that matter? What do you do to respond? And then what other considerations are there? So let's just jump right into it, because there's a lot to talk about. Types of requests. Okay, so the EEOC, the Equal Employment Opportunity Commission, along with about 5 or 6 other government agencies, enforces the employer's response to accommodation requests, depending on the type of accommodation that was requested and what area of the law is involved in your response and the request. So, but the EEOC is the main one. The Americans with Disability Act was officially created in 1990, was amended in 2008, and has broadened exponentially since it first came about. The definitions have broadened a lot and have been more loosely interpreted. So what used to be a little easier to interpret and implement has become much, much more challenging. I wish I could say that if you listen to everything I'm saying today and you follow these best practices and you play by the rules, that everything will turn out great and it will work in your favor. And by your favor, I mean what's best for you and your employee. The intent of any accommodation is to do what's best for the employee and the employer. It should be a mutually beneficial thing that works for both of you. That's not always how it ends up. And sometimes even if you do everything right, you lose in court. And that's the way it goes. I was studying a lot of these cases to prepare for this and had my mind blown a little bit at some of the results of the cases and even the context of some of the cases. So it can be very challenging. So I feel for you. I'm with you, and I'll do as much as I can to help you here, okay? The intent of all of these laws is to get rid of discrimination against individuals with disabilities. One of the cases I read was a person who was hired to give presentations to prospects and to speak at conventions representing the employer. She decided that her anxiety was too much, that she did not want to do that, and requested a basically surrogate, someone to stand in and present for her, that she would prepare the information, but someone else would present it. And then also if she had to go into a meeting or anything like that, that someone else would read her information. And I know those of you, some of you might be thinking, yes, that's perfectly fair. And some of you might be thinking, that's very difficult to comply with. That's going to cost a lot of money. You're going to have to hire extra people. That shouldn't be required. And you have to kind of separate if you have an emotional reaction or political reaction to what you think is fair or okay or just, separate that from what the law says and what the expectations are if you want to comply. And then also if you want to honor the spirit of the law, which again is to get rid of discrimination against individuals with disabilities, and also to boost employment opportunities for individuals with disabilities. That's really what it's about. It has not solved that issue, but it has made some progress. And so, regulation doesn't solve everything. It just solves part of the problem. Really, you need employers to kind of go above and beyond and say, I don't just want to comply. I also truly want a diverse workforce, and I would like to give individuals with disabilities opportunities in the workplace. So that's what it takes to achieve the spirit of this law. So ADA requests, we're going to talk about those first, and then we'll move into religious requests and then other kinds of requests. So what kinds of requests are you going to get with the Americans with Disability Act? You can get people who request schedule changes. They need to take longer breaks or more frequent breaks. Sometimes there are physical expectations. Oh, sorry, getting a phone call in the middle of this. And they may request leave of absence or say, I can't lift 50 pounds. They may want you to transfer some of the duties that are listed on their job description to someone else. May ask for an interpreter or reader. May ask you to modify the layout of the workplace. For example, if it's hard to get a wheelchair through a certain area of the office or from different levels of the office, or maybe even request adjusting certain functions, right? It doesn't mean you have to do every single one of these things, but these are the type of requests you might get. And I'm going to dig in pretty deep on each area that is relevant here. I am going to repeat this slide twice. And this slide is about the interactive process. But before I get into that, let me remind you, and I think everybody is muted. That's intentional because we're recording this and we're going to share the recording afterwards, so it just works better when everyone is muted. But you do have a Q&A function, so if you have any questions at all, you can enter them in the Q&A, and I have that pulled up on my other screen so I can see that, and I will try to answer any questions that pop up during the webinar. So feel free to ask anything you want to ask. I will not use your name, so the questions will be anonymous unless you put your name in the question. So the interactive process is really the most important thing. I'm going to repeat this on purpose because it is that important. A lot of cases have been decided against employers when employees request an accommodation due to disability or anything else, and the employer reacts too quickly without engaging in the interactive process. A simple way to describe the interactive process is just to say, have a conversation with your employee. Sit down with your employee and have a real conversation where you look at the position, you look at the job description. Hopefully you have a job description, and we will talk about that today. You're looking at the essential duties on the job description, the physical requirements of job, the working conditions in your work area. You're going to discuss what challenges you have. The way I like to do it is just say, if someone comes up to you and starts any kind of conversation about I'm having challenges with being diagnosed as bipolar, or my post-traumatic stress, or my knee, which has always been an issue for me, or my heart condition, or whatever, your question, a safe question to say, how is it affecting your work, right? You're not saying, tell me more about your diagnosis. Tell me what your doctor said. What is that? You know, do you have a family history? You're not getting into all of that kind of stuff. What you're talking about is how does it affect your work? And if someone says it doesn't affect my work at all, there's really no accommodation needed. But if someone says, yeah, it is an obstacle to what I'm trying to do and be successful here, then you need to have a conversation with that person about how it's affecting work, where the obstacles are, could those be removed or modified in any way? And you really need to show, document, keep notes of this process, that you are having this conversation, that you both shared ideas on how you might be able to get around it, that you might be able to accommodate, try to be creative as you can. Sometimes you need to take a little more time to think about it instead of just saying, we had a conversation, so I've done that interactive thing, and now I can move on and fire this person because we couldn't think of anything that would work. That will not play out well for you as the employer. And I know that there are two thought patterns going on here. Sometimes HR folks will come to me and say, look, I just want to know what I need to do to comply. I don't want to get in trouble. I don't want to be the one that the finger's pointing at when this is over with, right? And the other part of it is, you know, beyond regulation, I really want to help this person and I want them to succeed and I want them to have the opportunity that everyone else has to be a part of this company, to grow with us and everything. So both of those are going on, right? Remember, you are going to get templates for this. So you're going to get a questionnaire, you're going to get a full guide and everything that walks you through how to do this stuff. So we're giving you a lot of resources to go forward following this webinar. If you need it during the interactive process, so let's say the employee says to you, you know, I've got this condition and it keeps me from lifting more than 50 pounds. Well, you may say, you know what, I'm not a doctor, I'm not an expert, I don't ever want anybody to say it's my word against yours or that I'm doubting you or anything like that. Can we just get your professional medical opinion or your treating physician? And that way that will be our, you know, opinion of record. We'll act based on that. So if your physician comes back and says, yeah, you should never lift more than 50 pounds based on your condition, then we will make that a part of the record and consider that and go from there. Now, you don't have to do that, but you can if you want to. Make sure you document the conversation. Make sure you document options that you thought about. You know, what did you consider? And if there are things you ruled out, why did you rule those out? Because if this is ever challenged, you're going to need to justify the options that you considered and what would work and what would not work and why. If you're trying to say something was an undue hardship, if those of y'all are familiar with ADA, you know what that means, and we will explain it. Then you got to have some justification for that, because the undue hardship test is harder and harder to reach these days. And then once you have reached an accommodation with your employee, you've agreed on what works, you've agreed to modify whatever it is you're modifying, then it's good to follow up and say, how's this working for you, right? You still can hold people accountable for performance, but you also need to consider the effect of an accommodation and be realistic about that as you're following up on performance, okay? I see there are a couple things in the chat. Where can I find sample cases to review? That's a good question. If you go on the EEOC website and look under ADA, they have a bunch of examples of questions, or literally just Google ADA regarded as, or ADA record of, or ADA disability accommodation cases, things like that. Or if you go on any law firm, employment law firm sites, they will have examples of case laws as well. Trying to think where I downloaded some today. Yeah, I went to the U.S. Supreme Court. I went to a few law firm things. I went to the EEOC and ADA as well. And there's a bunch of options out there. Okay, so what is the Americans with Disability Act? We have highlighted specific words that we're going to dig deeper into in this webinar. The Americans with Disability Act is a federal law. And remember that even though this is a federal law that applies to employers with 15 or more employees, there are multiple states that require compliance with what they call the Fair Employment Practices laws, even if you have less than 15 employees. So you need to pay attention to that in your state. A few examples are Arkansas applies if you have 9 employees, California if you have 5, Connecticut, Maine, and Minnesota, if you have any employees at all. Indiana is 6. So different state laws may differ from federal law. You need to be aware of both, but I'm really only going to be covering the federal law specifically today, just in the interest of time. So the federal law protects qualified individuals with disabilities from employment discrimination and requires employers to provide reasonable accommodations unless doing so would create an undue hardship. So every one of those words, qualified, disabilities, reasonable accommodation, and undue hardship, have very specific definitions that sometimes help us and sometimes make it more confusing. And we're going to talk about each one of those things. It also prohibits an employer from retaliating against an applicant or employee for asserting their rights under the ADA. So if someone requests an accommodation and then they are terminated, they're probably going to have a pretty easy retaliation claim. So the timing is what matters with retaliation claims. And if an employer responds quickly, as they sometimes do, then it doesn't even matter at that point if the person was qualified or eligible for coverage under the ADA, because now their claim becomes just a retaliation claim. And retaliation is the easiest claim to prove because it's based on timing. I told you I had a condition, you fired me, we did not engage in the interactive process, so we never even got to figure out if I'm qualified or protected under the law or not, but you treated me as if I had a disability, which is called regarded as under the ADA, and you fired me. So retaliation claims are growing steadily year over year with the EEOC, and they are much easier to prove than any other claim because they're based on timing. So be careful of that kind of stuff. Okay, so we're going to dig into all of this, and I will continue to check the questions as we go through here and hit them every few minutes. So here we go. Okay, qualified. What is a qualified individual? So qualified individual is saying the applicant or employee must be able to satisfy the requirements of the position. So if you don't have a job description and you don't really have any way to prove what the requirements are for the job, then you don't have a lot to stand on. And there are a lot of companies out there that do not have any job descriptions, or the job descriptions they do have were downloaded like some generic sample off the internet, when it first came out in the 90s. So we see all kinds of crazy stuff with job descriptions. Job descriptions seem like they should be an old thing. It seems like in today's world that a job description would be something that you don't really need. And it seems like something that HR people used to do back in the day. But believe it or not, they are still highly relevant when it comes to situations like this, and can also be used with unemployment claims, with workers' comp claims, with training and performance management, orientation, all kinds of stuff. So I really encourage you to have updated, thorough, and accurate job descriptions. If you don't have those, that's something we help all of our clients with. So give us a call anytime. But to be qualified, you have to be able to meet the requirements of a job, be able to do the essential functions of the job with or without reasonable accommodation. So if you're interviewing an applicant and they come in with big, thick glasses and they're kind of leaning in like this and reading stuff, it's not a good idea to say, are you legally blind, or can you see what's going on here and whatever. But it is okay to say, in this job, you're going to be required to read tickets that are submitted through our ticketing system and respond to clients and support them to the best of your knowledge. Is there anything that's keeping you from doing that? Or are you able to perform those essential functions with or without reasonable accommodation? And then go from there, see what they say. So sometimes you do need to accommodate someone in the application process if they ask for that, as well as after you've hired someone, you need to try to accommodate them as well. So the ADA does not interfere with your right to hire the best qualified applicant, but it does prohibit you from discriminating against a qualified applicant because of his or her disability. So if they can perform the essential functions with or without reasonable accommodations, and they can meet the requirements of the job. So example, your requirement of the job says you have to have a valid driver's license, because in this job, you are going to drive a truck, right? So let's say you're driving for a auto parts store and you're delivering parts to, mechanics' garages all day. Well, if you don't have a valid driver's license, you know, you're not going to be protected under the ADA, because everyone can look at that and say, you got to be able to drive. That's the biggest part of the job, is driving a truck, right? So that stuff does matter, but you do need to have it documented and defined so you can explain what it is, okay? So make sure you have that updated job description with the essential functions, physical requirements, working conditions, experience, any other requirement that are all in there. Now, don't go nuts with your job description and just throw everything you can think of in there, whether it's relevant or not, because anytime you get a visit from the EEOC, the Department of Labor, Department of Justice, whoever it is, they're going to take what you present to them in terms of policies, forms, records, and all that. But then they're always going to talk to your employee. And what takes precedent over what you hand to them is when they say to the employee, what do you actually do in this job? And then they talk to other employees who have that same position and say, do you ever lift more than 100 pounds? And if they all say, no, I've never lifted 100 pounds in my life, and then they look at the job description, it says you have to lift at least 100 pounds, you've lost a little credibility there. So they should be accurate. It does require that you take some time to go through there. Okay. How are essential functions determined, right? If those are so important on the job description, how do we consider what that is? Well, to evaluate whether something is an essential function or not, you got to ask these questions. Is it necessary to perform the job, or is it just a nice to have, a wish, you know, a luxury? If it's something you absolutely have to do the job, then that's an essential function of the job. For example, used to have a lot of property management company clients, and one of the things they had as an essential function is if you were going to be marketing apartments or showing apartments to prospective renters, one of the essential functions was you need to be physically present and have the ability to walk up and down stairs to be able to show these apartments. And if you're not able to be here physically at the location and to walk the property and go up and down stairs, then you're really not qualified to do this job, because that is something that you're going to have to do every single day, right? Warehouse workers might have lifting minimums. Truck drivers need to get a valid driver's license. You can even say you have to have a certain driving record that meets your standards. If you're hiring a front desk employee, they're going to need to be in the office to greet visitors, right? Walmart can't have a greeter who's not there. At least I haven't seen them do that yet. I guess they could now in a virtual world, but so far they haven't decided to go that route. HR consultants on my team, they need to be able to access and retain employment law, compliance information, and best practices, because that's some of the stuff that we're getting paid to do, and we want to give the right information to our awesome clients. Other things you can ask is, how frequently is the task performed? How much time is spent performing that task? So if you say it's essential, but they hardly ever do it, and when they do it, it doesn't take much time, it's just going to be hard to argue later that somebody else couldn't do that for them if that was a accommodation that was requested. So can the task be redesigned or performed in another manner? Can the task be reassigned to another employee? All of those are things to consider when you're thinking about essential functions of a job. Mainly just sit down and go, okay, what does this person do every day? What do they do a lot of? What do they need to do well to be successful in this job? How is their performance measured? Do we have metrics in place? And what are those metrics driven by? All of those things you can look at when you're thinking about what are the essential functions of the job. Just remember, don't exaggerate that or get crazy with it. You need to be realistic about it, okay? So in addition to the job description, like I said, the EEOC is going to ask questions. They're going to consider the actual work. They're going to talk to present and maybe even past employees in the job. One thing that I have learned from 20-something years in HR is that I have never seen an employee who said, you know what, I'm going to lie to protect my employer. That does not happen in my experience. I've never seen that happen. I've been through OSHA audits. I've been through environmental protection audits, Department of Labor audits, I-9, wage and hour, you name it. And I've never seen an employee who goes, you know what, I'm just going to say whatever I need to say that protects my employer. That does not happen. So if you think that's going to happen, you are mistaken. You need to do it right so that when people tell the truth, you're not in trouble. That's really the only way to approach this stuff, is say, I'm going to do the right thing, which, by the way, was why I joined Thread. This is a tangent alert. is I was having a conversation with Lori Winters before I joined Thread, and she said, you know what, I'm always going to do the right thing, whether it costs me more or is inconvenient. And it really struck a chord with me, and that's why I chose to be here. So, and I'm still really, really excited to be here. And Lori has proven that she does do the right thing, and we as a company try to follow that and do the right thing as well. So it's an awesome place to work. All right, back to what we're here to talk about. Essential functions, right? Time spent and then the consequences of not requiring that an employee perform a function. So what would happen if they didn't do it? If there's no effect to them not performing this function, then it's probably not an essential function. And now, what is considered a disability? Okay, there's a lot here, but under the ADA, the person has a disability. So they remember the two parts. They have to be qualified and basically have a disability, right? Or have a record of having disability or being regarded as having disability. We'll talk about that. All right, so person has a disability if he has a physical or mental impairment, which is ongoing or temporary. So it doesn't have to be a thing that lasts forever, that substantially limits a major life activity. And we're going to define what those are as well. If you answer all of these questions, you start to hone in on what you should be doing and not doing and what this means and when it applies to you, okay? The thing that a lot of employers miss, and a lot of even experienced HR people, because I interview HR people a lot, and I've been doing it for a long time, and a lot of times they miss this part of the ADA, which is that the ADA protects people with a disability. It also protects people who have a record of a substantially limiting impairment. So an example of that would be someone who had cancer. They've been through hell and back, and now they're in remission, but they have a record of having that. So they are protected under the Americans with Disability Act, even if right now they're walking and talking and doing everything fine, they're still protected, okay? And it also protects people who are regarded as having a substantially limiting impairment. And I'll talk a little bit more about that. So regarded as includes you discriminating against someone because of an actual or perceived impairment. They might not have an impairment at all. And by the way, if they don't have an impairment, so for this, these are called the 3 prongs of ADA, right? One is you have a disability that substantially limits major life activity. Prong 2, you have a record of that. Prong 3, you are regarded as, or basically treated as if you have a disability, even if you don't. So on prong 3, if you are regarded as or treated as if, then you are not required to provide a reasonable accommodation because there is no disability there, if that makes sense. So if you treat me as if I have a disability and discriminate against me, then I could have a claim, but you're not required to provide a reasonable accommodation if I don't actually have a disability, okay? So what could be a form of discrimination, or how would you, what kind of adverse action would you take that would be considered discrimination or in violation of the ADA to someone who does not have a disability but is treated as if? If you refuse to hire them, you demote them, you place them on involuntary leave because you think they're not able to work, you terminate them, or you exclude them for failure to meet certain qualification standards, if you harass them, or this is the catch-all part of the definition, denial of any other term, condition, or privilege of employment. So just be careful. Don't treat people as if they have a disability or discriminate against them as if in general, but even if they don't have a disability, you could be in trouble for that. So I read a few cases about that. One of them was a person who worked at a car dealership, and she had had knee surgery a while ago. They wanted her to look under all of the cars on the lot to kind of just inspect them on a regular basis. And she had requested that they give her a handheld mirror. So instead of her having to get on her hands and knees and look under the cars, she could just hold that mirror down there. And they ended up letting her go. But the court, let's see, accepted the case and says that she was regarded as having a disability because the car dealership assumed that she could not perform the job because of her knee situation, even though she was recovering from knee surgery. It was a temporary thing, was not going to last forever. And so that case is going to trial. There was another one about a person who requested a transfer in the warehouse, said he couldn't lift 50 pounds anymore. And that was a temporary thing. He was having some back issues, shoulder issues. They let him transfer the job, but when he did transfer, he complained about his shoulder injury again, and the company let him go. It wasn't a disability. It was just something that was kind of bothering him. And they did treat him as if he had something that physical condition that would prevent him from doing his job well, even though he did find somebody else to replace the lifting component of the job, and that was going to court as well. And there's a few more, but there was a case years ago about a grocery store employee who was terminated because the manager walked out one day and saw the guy limping in the parking lot and said he can't go out and gather grocery carts because he clearly has something wrong with his ankle. And the employee had just strained his ankle a day or two before. It wasn't a big deal, but had a claim under this third prong. So that's the kind of stuff I'm talking about, okay? Physical include, in terms of physical impairment, okay? Physical impairment could be blindness, could be something like diabetes, deafness, epilepsy, cancer, MS, cerebral palsy, emphysema, HIV, muscular dystrophy. Mental disabilities or impairments can include schizophrenia, learning disabilities, intellectual disabilities, autism, bipolar disorder, post-traumatic stress syndrome. All of those things could be included and be considered impairments under the definition of disability. Okay, I got a couple questions here. Let's see. Have an employee that I suspect needs an accommodation. When I completed the interactive process in the past, the physician said accommodations weren't necessary. Now what? Oh, interesting question. So there's nothing wrong with going back to the conversation. So once you've had the interactive conversation once, it doesn't mean that you cannot continue it. Once someone has asked for accommodation, if they need it, whether you were able to accommodate them or, you know, whatever happened, if they're still employed, it's worth following up to make sure they're okay and doing what they're doing. So if someone is asking for an accommodation, then I would basically restart the interactive process with them. Just start now. Really, whatever happened in the past, you know, may be relevant in court, but in terms of what's happening right now, it's not that relevant. You can just get with them and say, let's start the conversation. Let's talk about how things are going now. If they have not requested accommodation, then you don't have to give it. Now, what you can do is manage performance. And if someone is underperforming, it's always a good idea to talk about what are the obstacles to their performance, right? And sometimes that's when it comes up, and then you can address it then. Hope that makes sense. Another question said, employee has worked remote since the pandemic. Doctor says the employee is unable to work on site until further notice with no other explanation. Yeah, I think, you know, as an employer, you've got to decide, can you accommodate that or not? And we are going to talk about undue hardship in a minute, what qualifies. It's harder and harder to prove the undue hardship thing. I'll just lay that out there now. People used to say if it was more than a de minimis cost, then it qualified as undue hardship. But there have been multiple cases now that have surpassed that de minimis, which means, you know, a little cost, to say it's got to be substantially more than that to qualify as an undue hardship. And it also has to do with the size of your budget. Like there was a case that said a nurse had requested a basic accommodation, and that required the hospital to pay an interpreter. Well, if you were a small local hospital that didn't have much of a budget, that may qualify as an undue hardship. But if you're a huge hospital that has $1 billion annual budget, you're not going to be able to claim undue hardship for that. You're probably going to be hiring an interpreter, right? So perspective does matter. I know that a lot of employers struggle with the request for remote work. I think overall you have to decide as a company what you're okay with. Are you flexible, and do you have the managers and the metrics in place to manage performance effectively? Thread is a remote workplace. We all work remote. Some of us come in the office by choice 1 or 2 days a week, but none of us are required to. Pre-COVID, we were all in the office every day. So that has been a change for us, and we are adjusting to that like everyone, but we've learned to do it. And it really comes down to, do you have really good performance metrics in place? Do you communicate well with your employees? Are you set up in the virtual world to be able to manage and work together, and go from there? So you just have to decide, does this position require that the person is in your office? Now, unless there's a physical component to the job, like, lifting boxes or doing this or that, it's harder and harder these days to make the argument that you have to be at work, because so many people are not at work anymore, that they're working from home. So just consider that if you want to challenge it, you've got to have some kind of precedent to prove why someone needs to be physically in the workplace. If you can accommodate them working from home, then great, go for it. What happens if you provide an accommodation, but it isn't the accommodation they want? There is nothing in the law that says you have to give the accommodation that the employee wants. Now, they will probably request specific accommodations, and the most likely scenario is that that's what you're going to try to do if it makes sense. But sometimes you may come up with an alternative accommodation that still enables them to do the job, and they might not, favor that accommodation over what they wanted originally. But if it meets the standard, then you can move forward that. And you can say, we had the conversation, we looked at all our options, we come up with an option that works. The employee doesn't prefer it, but it is something that works and accommodates them. And then you can, see what happens and go forward with it. Now, you may still have issues with them if they're unhappy with it, but it is okay to do that. All right, so what is a major life activity? These are examples. Remember, you have a qualified person, which means they are meeting the requirements of the job, right? They can perform the essential functions. And we talked about how you determine essential functions. You should include those in your job description. And then, if it substantially limits a major life activity, so physical or mental impairment that substantially limits a major life activity, these are examples of major life activities, right? What falls into those categories. So it pretty much covers everything. All of our senses are included, our physical performance as well, how we communicate. And then it even includes breathing, because remember I mentioned emphysema. Thinking is in there as well. That is a really hard one, and I understand that. I have been challenged by that multiple times in my career, where you're looking at someone and they look totally fine. They don't look like they have a disability, right? And that's the challenge with anyone who is struggling with like PTSD, for example, right? You have conversations with me and I seem fine, and on most days I'm great and I get the work done, it's no problem. And then every once in a while, when I say, I'm really having an episode here and I'm having a hard time concentrating or being productive at work, some people are skeptical about that because they're like, I just can't prove it, right? We all have that human nature thing where I want proof. And in some of these situations, you're not going to get it. And that's going to be very challenging. So it's like a workers' comp claim. No one was there. No one saw the person get hurt. Not sure if they get hurt on the job or not, but they submitted a claim. Now what do? Well, let's file it and see what happens. Let's investigate it. Let's go through there. You just do what you can do. And then you try to accommodate as much as you can. You try to understand what the challenges are and what the obstacles are, and see if there are ways that you can overcome those, modify those, and accommodate the person if possible. Let's see here. I'm looking at the questions again. Let's see here. Okay, I'll jump back to that in just a minute. Okay, reasonable accommodation. I hope y'all are still with me. I love the fact that everybody's still on. I appreciate your attention. Reasonable accommodation can be a modification or adjustment to the job, can be an adjustment to the work environment, and I'm going to give you some specific examples here, or just the way things that are usually done that provide a qualified individual with a disability an equal employment opportunity. Now, we are repeating things on purpose because anyone who knows me knows that I do that. And I know the folks who used to work on my team are rolling their eyes and laughing at the same time right now, including the folks who work with me now, because they all know, yeah, Scott is like Mr. Obvious. He repeats stuff over and over, and I do that intentionally. So sorry, not sorry. I just think it's a great way for people to learn if they hear it multiple times, so much that they say, you know what, I already know what you're going to say before you say it. That's kind of how we do things. So reasonable accommodations. The intent of the reasonable accommodation is to make sure you're ensuring an equal opportunity in the application process or the employment process. You're enabling the qualified individual with this disability to perform the essential functions, or you're enabling them to enjoy equal benefits and privileges of employment, like training opportunities, right? Everyone in this certain department has earned a trip, but you have some physical disabilities. They're going to make it a little harder to travel. What happens if your employer says, well, everybody else gets to go, but we just can't afford to send you because that would require renting an extra van or something like that? You know, not only is it uncool, it's not a great move as an employer. It's not really respectful. If someone earns it, just like everybody else, they should get it, you know? So think about that when you're making those kinds of decisions, right? Examples are providing or modifying equipment or devices. So it may be that you add something to a specific piece of equipment. Had a client one time whose job was to, he had to empty dumpsters in several manufacturing and warehouse facilities. So he would drive around in a forklift and he would move these dumpsters, but then some of these dumpsters, sorry, had this contraption where you had to actually climb up on top of the dumpster and pull a lever, and that dumpster would just wham like that dump into the truck. And not only was it extremely dangerous, the person had developed a condition where it wasn't easy for him to climb up on those things. It wasn't easy for anyone to do it. And so we just added a giant like bar with a hook on it that was attached to that lever, so the person could literally drive up in the forklift, grab that bar and go boom, and it would dump the dumpster like that. So it was just a smarter way to do it, a safer way to do it, an easy accommodation for them to give. It didn't cost much money, and it satisfied everything that needed to be done there, okay? Job restructuring can be a little bit harder. The EEOC basically says, look, if other employees are inconvenienced, that's not their problem. And it's also not your defense. So it's hard to say, well, if we do this, we're going to inconvenience other employees. Or a common defense used to be, this is going to cause us to have overtime among other workers on the team. And they have also come out and said recently that, hey, a little bit of overtime isn't going to kill you. And so that's not really in defense either. Now, if it caused a lot of overtime and was a sizable expense, then maybe we could talk about it. If someone wanted to go part-time, that's okay. If you wanted to reassign them to a vacant position temporarily or even permanently that worked for them, you know, as long as you're not saying, hey, we're going to pay you a lot less and demote you and everything else, then, you know, using this, we're offering you another position. If it costs less and is like lower status within the company or whatever, then it could be viewed as a demotion and that could come back to haunt you. Adjusting or modifying like training materials or how you measure performance, sometimes even policies may be necessary. You might be required to provide a reader or an interpreter, or make your workplace more accessible, right? Now, we originally, all of us heard about disability accommodation when it came to like retail stores, right? Accessible bathrooms, doors, aisles, things like that. And then it worked its way into the workforce and employers and employees. And that's kind of where we get involved the most, is in those situations. So what is not a reasonable accommodation? This is a question I get a lot. Removing an essential function of the job is usually not required. You can do that if you want to. I know I mentioned that earlier as a possible thing, because it is possible if you're willing to do it, if it's not truly an essential function. But if you really do have an essential function listed on your job, you're not required to remove that. You don't have to lower your production standards. In other words, you don't have to say, okay, we'll make this accommodation, but by doing so, that affects the quality of our product, which means we're probably going to lose business and be blasted on the internet and everything else. You don't have to provide personal items such as a prosthetic limb, a wheelchair, eyeglasses, hearing aids, or similar devices if they're also needed off the job. So if someone already needed that, whether they're working for you or not, you don't have to require that provide that, sorry, as part of your accommodation. All right, so now we're to what is undue hardship, right? It gets a little interesting here. And I looked up some specific information because you got to dig into every one of these words as well. So accommodation would be unduly costly, extensive, substantial, or disruptive. Sorry, obviously didn't do the turn the phone thing off today. I should have. Or would fundamentally alter the nature or operation of the business. Now, that's a big claim. Fundamentally alter the nature or operation of the business. That's going to be hard to prove unless it's a real biggie, okay? And then again, I mentioned what you're not required to do right there. But example of what have courts said about the two big things I looked up were disruption to the operation of business and expense, which are the two most common routes that employers take when they say this does create an undue hardship. So in terms of expense, there is no specific dollar threshold. So again, we're left in this gray area where we really don't have an answer here because, $1 million to Oracle is very different than $1 million to Thread, right? We're not a huge corporation like that. And so their perspective does matter. So that's why they don't give you a specific dollar amount. Otherwise, people would jump all over it and use it, even if it was just a tiny percentage of their budget. So no specific dollar amount. Courts look at undue burden based on the company's net worth. So the example that they gave earlier was a nurse requested the hospital that they hire a sign language interpreter. This is what I mentioned earlier. The hospital said that the salary was too high and they couldn't do it, but the court disagreed because of the hospital had over $1 billion budget and the cost of the interpreter was too marginal to disrupt their operations. In other words, we're going to be that big of a deal. If they had been a really small business, then it might have qualified as too big of an expense. So the perspective is what you're looking at there. If you look at a dollar amount that you're going to claim is too much, and then you say, you know what, we spend that every year at our company party, or we spend that on, trips or whatever it is, you're going to have a hard time arguing that you couldn't spend that money, okay? Disruption to operation of business. An employee who requests a substantial amount of time off work might have trouble getting their employer to agree. A shift lead at a woodworking company requested 3 months off work to recover from surgery. It was rejected on the basis that granting the additional leave would be an undue hardship, and the employee was fired after FMLA expired, and he sued the company for wrongful termination. And I can see all the HR brains turning out there right there. I feel the energy coming from your names off my screen here. So I wonder if you think that was okay or not okay in the eyes of the law. The company stated that holding the worker's job due to extended leave rather than replacing him would significantly disrupt their business. The company was planning to operate at its normal level of productivity without placing an undue burden on other workers. It would have to hire someone to take that employee's place. However, to give the employee his job back, they would need to make that new hire's position temporary. And because of the requirements of this job, they all agreed that applicants would not be interested in accept a temporary contract or assignment, and the courts agreed, and the employee did not get his job back. So some of y'all might be surprised by that. And that's the interesting thing about ADA and these accommodations and the claims that come under ADA and the EEOC is that sometimes you're like, well, it doesn't always make sense the way things turn out. So I always just say, you know what? Don't try to predict results. Just do what you're supposed to do and do the right thing. And if you do that, most of the time it's going to work out. Your employees will understand that you have the right intentions, and it should be fine. So other things that could be considered undue hardship, you don't have to do things that will reduce worker safety, expose others to threats or the employees to extreme threats if you can prove that. Things that infringe upon other employees' rights, may hurt others' employees' benefits, lower job efficiency, or obviously if it breaks another law, then you're not required to do that. Okay, so now we're to the point where we're going to talk a little bit about responding to requests. And you're going to see a slide that you have seen before called the interactive process. And yes, I know this is in here twice, and that's on purpose. The interactive process is the number one most important act that you are going to take anytime you get an accommodation request from an employee, okay? So remember, if you forget everything else from today's webinar, the main thing you need to remember is if an employee comes to me and asks for accommodation, I need to schedule the time with the employee to have an honest and thorough conversation about how this is affecting their performance. We need to review the job description. We need to talk about the requirements of the job. I need to learn more about what the obstacles are to performance here. Consider possible accommodations. And again, this doesn't mean one conversation. You can have multiple conversations. You can involve several people if you want, if they have expertise that might be helpful. You obviously want to keep this as confidential as possible, kind of a need to know thing, and have the conversation. That's the most important part, right? How does this affect your work? What are your ideas? Remember that you do not have to do the one thing that the employee requests, but you do need to try to be creative and be thoughtful and think outside the box a little bit about how you could make this work and try as hard as you can to make it work if you want to avoid liability. But besides the liability, also, you're trying to do the right thing here. You got a great employee who you asked to join your team. You were that employee's best option, and the employee was also your best option. Otherwise, you wouldn't have extended that offer, and he or she wouldn't have accepted it. So let's do our best to make it work. Turnover sucks. All managers and HR people know that. Turnover is a drain and a cost. And even if you wanted somebody to leave, it's still a hassle, and it's hard to hire new people, find good people, train people, keep people. So in my opinion, any effort towards helping people succeed when they're already on your team is generally worth it. Okay, I'm going to check the chat here and the questions. Let's see here. What if the accommodation is provided, but the employee feels that they were discouraged from pursuing it or that it was granted reluctantly? Well, that could be a problem, and that is really more of a training issue with your management team, and that does happen. That's a good question, because this is something that is common when employees have any kind of accommodation request or any kind of harassment complaint or complaints in general, right? We have all seen managers who react emotionally, who, why can't everybody just come to work and work hard and keep their mouth shut and do what they're told, right? And a lot of folks have that opinion, which is great, but not everybody does. So as a professional, effective manager, you have to separate sometimes what your personal feelings are from what is the right thing to do in the workplace. And that is very, very difficult to do. And it is advice that we give to our clients regularly when managers are named in a complaint specifically. They have a very hard time. Sometimes what they want to do is ignore that person going forward, because they say, I don't want to say anything that's going to get me in trouble. Well, then the person will say they're ignoring me, and that's a challenge too, right? Sometimes they will act in a way that lets the employee know that they're not happy with them, or things like that. So you just got to be careful with that and make sure that your managers are trained and they knew how to do their job professionally, and that they understand what the stakes are when they're handling situations like this. Okay, 5 biggest common mistakes, and we're getting towards the end here, so I appreciate y'all hanging with me. I know this is a lot of information, but this will come in handy along with all of the resources that we're going to give you following this webinar. And remember, Thread does these free webinars about quarterly throughout the year. And if you are an HR client of Thread, then you also get exclusive scenario-based things, which we call broadening your HR knowledge, every single month, where we have interactive scenarios where we talk about what should we do in this situation, what's the best thing to do, what should you say and why. And those are great training opportunities if you're a client of Thread. If you're not an HR client of Thread, you're missing out, man. Give us a call, and we're fun to work with, and we have a good time, and we get a lot done, and we are affordable. So consider that. All right, five big mistakes. Not realizing that a request has been made. So, you really want someone to ask for an accommodation clearly, but that doesn't always happen. Like one of the questions earlier was, I think they need an accommodation, but they might not have asked for it yet. So in those cases, I kind of go back to performance management and how well you're managing performance. You're looking at metrics and key performance indicators, and you're talking with your employees regularly. You're having one-on-ones. You're paying attention to what the data shows in terms of your metrics and everything else. You're asking them how they're doing. Are they happy here? All of that. You really have to stay in tune with your employees all the time to do a good job managing their performance and building the culture that you want at your workplace. But if you're doing that, you're going to know if something's going on, and you're probably going to have a conversation about it. If you permit frontline supervisors and managers to evaluate the accommodation request without HR, in most situations, that can get you in a little bit of trouble later on, because even though they might know what ADA is and they might understand what an accommodation request is and everything, I'm not, talking down about managers or supervisors at all. I'm just saying HR folks have gone much deeper when it comes to what's required in the accommodation process, what laws are behind that, what case law has come about recently that could affect how you approach the situation. And it's your job to research and be aware of how to do this. So make sure HR is involved. And if you have never done this before, that's a great reason, to work with someone like Thread and our team. You get an HR advisor and HR specialist who are, certified and experienced, and they're going to walk you through how to do things like this. So you do it right. Don't delay the response. So if someone has an accommodation request, you don't want to go, well, I can't talk about it till 2 months from now. Well, things could be getting worse. If someone's not able to do part of their job, they could be catching flack from their coworkers, and then that's just going to pile up and make it harder and harder for everybody. So get right on it, take it seriously, respond like you would to any other kind of claim, right? Discontinuing the interactive process because you have not thought of an obvious, reasonable accommodation. This happens where you say, we met, we talked about it, we couldn't think of anything, so we've done that, it's over, and we're just going to let you go, or just say you got to figure it out on your own. That's not the smartest way to do it. You need to revisit, make sure you have exhausted every potential opportunity, looked at that list of different types of accommodations and said, could we do this? Could we do that? Could we do this? And really take your time to go through it, work with the employee, get ideas, maybe even bring in experts, who might have ideas, look up stuff online and just document as much as you can to prove that you're trying everything you can to help, right? That brings up number 5. If you inadequately document it, this is true just like it is with everything else in HR. We're all known for saying you've got to document it. You got to be better at documenting it. No one likes documenting things. Almost every company I've ever worked with goes, yeah, it's just hard to do. We don't like doing it. Our managers don't like doing it. It's kind of a pain. It makes things seem confrontational when we write it down, like we're building a record against the employee, but it doesn't have to be that way. So when a company or a manager comes to me and says, hey, documenting this stuff makes it confrontational, what that tells me is that the performance management process needs a little bit of improvement. The manager needs some training about how to do it and how to talk about performance, how to give feedback with their employees. So it's not confrontational, because it doesn't have to be at all. And documenting it doesn't have to be confrontational either. If you have the conversation in the right way, anytime I'm documenting something with an employee like that, I'm doing it right in front of them usually. And then most of the time I let them read what I wrote and say, if you have anything you think is different than what we both said, let me know and we'll change it. And then we'll both sign this saying that, yeah, this is what we talked about, right? It's just completely transparent and right up front and easy, and nobody feels like you're trying to do something behind their back. So that's just how I do it. You don't have to do it that way, but I find that it's easier later on when you've done it that way. If you have well-trained and experienced managers who really pay attention to performance and ask employees about obstacles to performance with the intent of providing support and resources to set them up for success, then you'll be okay. That's the key. But make sure your managers all know, if anything like this comes up, come talk to me. They don't have to know the ins and outs and everything else. They just need to know, come talk to me, okay, in HR. We got a few more things to cover real quick, so just hang on here. EEOC enforces federal laws that make it illegal to discriminate against the applicant or the employee because of race, color, religion, sex, including pregnancy and related conditions. The thing that comes up most often related to pregnancy is when a manager says, you know, I can see that you're pregnant, so I'm going to take you off of this job until after you come back to work. Well, the pregnant employee might say, I don't need to be taken off this job. I'm fine doing it. So with pregnancy, treat pregnant employees just like you would treat anybody else. And that's the safest way to do that. Okay. If they say they can't do something, then you talk to them about it. Gender identity and sexual orientation, we're going to talk about that. So the biggest other things are really religion and gender identity that come up the most often in terms of questions with us. Okay. So we've talked about ADA a lot. Now we're going to talk a little bit about religious requests and then other. So religious requests could include things like, I need to take breaks, more breaks to pray, longer breaks. I can't work on a Saturday. I need to wear a certain item of clothing or not wear something you're wanting me to wear. Or if I'm working a pharmacy, I don't want to just, you know, hand out birth control pills or whatever it is. Those kind of things do come up. And when it comes to religious accommodation, you really need to try to accommodate the employee's sincerely held religious beliefs or practices, again, unless it's an undue hardship. So the undue hardship is harder to prove, but it has to do with like scheduling and all the other things that we mentioned before. Now, the challenge with religion is a lot of people think the religion, what I've heard a lot of people say is this only protects like religions that are not mainstream, which is not true. It protects all the normal religions, not normal, sorry, but the traditional religions that most of us are familiar with, Christianity, Judaism, Islam, Hinduism, Buddhism, you know, but it also protects new uncommon beliefs that are not part of a formal church or only held by a small number of people. Also, it can be considered sincerely held even if the person has newly adopted this belief, does not consistently observe it, and it's different from commonly followed tenets of that religion. So you can't just get on Google and go, well, I Googled your religion and it says you do this. Well, that person might say, well, yep, but I do things differently, right? Just like, you know, I grew up Catholic. I didn't do everything that Catholics were supposed to do, right? Some people do it all and some people do pieces of it. They pick and choose, right? That's how religion goes. So it is defined very, very broadly. And also I want to mention that if you are a religious organization, if you're a church or qualified as a religious organization under Title VII, and including religious educational institutions, it does allow you, those organizations whose purpose and character are primary religious, to hire and employ people who only share their own religion. So in other words, it is not unlawful, another way of saying it is lawful, to basically discriminate on religion for a qualifying employer to limit who they hire in that way. So a Catholic church can say, we only people who hire people who are Catholic, right? They are protected and it's okay for them to do that. They also apply a ministerial exception that bars certain employment discrimination claims by employees of the religious institutions because those employees perform vital religious duties at the core of the mission of the religious institution. And that's the official language. So just know that that's out there, and churches are protected in those ways. Outside of that, most religious accommodations, you need to do your best to accommodate them. And these are examples of some of those accommodations that might be requested. Catholic asked to change his schedule so he can attend church on Good Friday. An atheist says, I don't want to be present if you're saying a prayer at the beginning of every meeting. Seventh-day Adventists will say, I don't want to work on Saturday. That's my Sabbath. And then the interpretations of the law say an employee should not be forced to choose between her religion and her job. So if you say to someone, you know, this is the way it is, you either decide if you want to be true to your religion or you want to work here, you're kind of setting yourself up for failure in that situation, okay? What could qualify as like a hardship or a burden that could protect you if you say, I'm not able to do this? These are examples, and we're on the last few slides here, I promise. If you're not required to violate a seniority system, those come into play in union organizations pretty often. If it will cause a lack of unnecessary staffing, that could be an issue. Now, you can't just say, hey, we're going to be down one person this one day, but if it causes a problem, you could try that. If it's going to jeopardize security or health or cost the employer more than a minimal amount, again, not defined, so hard to prove. But these are examples of that. That if you have to occasionally pay overtime or substitute a shift or something, that's not a big deal. And if you have customer preference or coworker disgruntlement, that does not justify denying a religious accommodation. So remember that, because those are often present in these situations. Lastly, another thing that is comes up in questions we get sometimes, this is a challenging answer for some people, but it is an easy answer to give because it is very clear and has been upheld over and over and over again in almost every court case that's been challenged here. So relative to sexual orientation, if someone looks like a man but says, I'm a woman, I identify as a woman, then that person is protected to use the women's bathroom, the women's locker room, including the showers and everything else. If you have, as an employer, designated men's restrooms and women's restroom, the people who identify as men get to use the men's, and the people who identify as women get to use the women's, regardless of what you see or believe or feel about it. That's the way the court handles it. And so if you prohibit someone, a transgender person, from dressing or presenting consistent with his or her identity, then that would constitute sexual discrimination. And that has been added to the law. So if you look at your updated lists under the EEO protections, that language should have been added if you have an updated policy, okay? You're also not allowed to segregate employees based on actual or perceived customer preferences. I've had clients before who had, customers complain about someone who was going through this situation. And it's a very challenging situation for an employer because they're like, I don't want to lose customers. I don't want to lose business. This is what we're in business to do. But you can't just say, hey, a customer complained, and so you got to go work in the back or anything like that. And those are things that employers have tried sometimes, and that won't work. So be careful with that. These are the things that you are going to get for free following up with this webinar, a bunch of helpful resources. And I appreciate your time today. Thank you for being a great people leader and for caring about HR and employment law. And if you have any follow-up questions or anything like that, my email is on the first slide of this presentation. So feel free to reach out, connect on LinkedIn, shoot me an email. And if you're not working with us yet, come on, join the team. It'll be fun to work together. Have a great day.